society at large. Thank you all.
Thank you very much, sir, for your knowledgeable speech. Now we are coming to the last part of our formal program. Now I request Sri Naresh Malligamadu to propose vote of thanks.
Respected Chief Guest, the guest of honor, Principal, invitees, and my friends, I stand before you to propose 2 words. Thank you. First and foremost, I thank Honorable Justice Hulwadi G. Ramesh, Judge, High Court of Karnataka, for inaugurating this auspicious program, Copyright and Patent Right for Laymen. Thank you, sir. I thank Dr. B.M. Hegde, former Vice Chancellor of Maya University, for presiding over this function, which actually added glamour to this function. I thank our beloved Principal, Dr. B.K. Ravindra, who is actually a source of inspiration for all of us, and without him, this function or this workshop would not have been arranged. So thank you, sir. I thank Sri G. Dakshinamurthy, Director, represent Kilpa, and she is with us. Thank you, madam. I also thank Dr. Devaraj, Principal of BBM College, for his presence and support. Thank you, sir. I thank all the invitees, resource persons, delegates, members of the press and media, and all my beloved students for witnessing this formal function. Finally, I thank this function. Thank you very much.
Thank you, Naresh, sir. Now we shall be commencing our entry room and to have your breakfast or light refreshment. Yes, I request once again, please move to the adjoining room and your. Now I request Sri Naresh sir to honor our dignitaries. Now I request Mrs. Balika to start the initiation.
Good morning, one and all. Today we call it a knowledge era. But when Galileo for the first time invented telescope, it was said that Galileo who invented, but in fact it was a different story where the people who are dealing in traders in lens, who when they were making use of those lenses in different, when they held in different directions, they found that they can observe the things which are in faraway place very close. And when the information was gained by Galileo, he also was keenly interested in, he took that idea and he manufactured his own telescope for the first time and he observed the sky. Of course, it is not for the invention for which patent was available then. But after the invention of telescope, whatever the observation he made, by observing the sky and analysis that he made out of it, and he wrote in a book, he published it. For the publication that he made, he was not rewarded with the copyright, but instead he was home imprisonment, house imprisonment.
Begin the entire session with some problems which we got. Half an hour earlier, we are discussing that all the patent agents in India were technicians, not lawyers. We got in our institution IIT, IIMs, all MTechs, MScs. Why not a lawyer? They did their MTech, PhD, and then studied for the heck of studying LLB, and then passed patent agent examination, and they become patent agents. No, it is all what is there within you to understand the flair of technology. An advocate need not be a scientist, but he should have a vision to understand a scientist, to define science in the technical language, in the legal language. No, we are confined our discussion to patent law and copyright law. Intellectual property rights, every discussion of the law begins from jurisprudence. As Mr. Hegde was quoting, what is a right? There are developments with regard to copy left, copy wrong. Have you heard of it? Copy left. GNU free softwares, Linux software, anyone use that? It is a free downloadable. You know that? AVG antivirus, it is a copy lefted software. We leave it. Anybody who wants, he can download it free. No copyright for that. No, this is how they arise. No, I got some property. I know that you will snatch it. Even after having all the type of protection. It's better to give it to you. No, which one is better? No, what our students do is, they go through the acts. When they go to interview to the firms, they were asked the question, to file a copyright, which is the form? Nobody is concentrating on the rules, copyright rules and forms with regard to filing the copyrights or patents. You just go through the Form 4 of Copyright Act. Assignment deeds, author and the person who is claiming the ownership of copyright. And categories, of course, your literary works, dramatic works, musical, cinematographic films, computer software, what right and what wrong, everything is copyright. Even for the matter of designs, you can protect the copyright in designs. You can protect the artistic quality of trademarks through copyright. You may be heard of a book written by Newton called Principia Mathematica. Anybody? Principia Mathematica is the first book on mathematics and principles of science, physics basically. It ranges to a 900-page book. And Aryabhatiyam, another book written by an Indian author, Aryabhata, which contains 131 shlokas. Almost the matter is same. Now you compare, where is 900 pages of book, where is 131 shlokas? It is all expressions, how you express. Original expressions, copyrightable. Expression, say for example, Mahabharata, how many versions you found? How many versions you will find in the market? All get copyright. How? Different type of expressions of a known story. Computer softwares. Everybody is writing software through Java or C or Basic or COBOL language. How they are getting? It is all how you are differentiating in source code. You should know some technology, some flair towards technology to understand technical aspects of patent and copyright. Everything is literature. There are technical literatures and non-technical literatures. That's how it is. Now say for example, last week we are filing a patent application with regard to Indian Institute of Science with a laparoscopic tool. Laparoscopy, anybody heard of it? It is an operation instrument without cutting much part of your stomach, inserting a scissor and repairing your parts, internal parts. Traditionally, laparoscopic instrument got 9 patents in USPTO, United States Patent and Trademark Office. Now what they did is, laparoscopic tool, you may be, seen that there will be a hand like a scissor, in front there will be a scissor. You operate this, this will operate like this. Now what they did is, they added a universal joint here, like your steering rods. Now this operates in this direction, wrist movement they call it. And they are claiming that this adding of a universal joint is an invention. 9 already existing patents. This is the 10th one if we get, or if we are successful in getting the patent or convincing the controller of patents. It is all how you visualize the technology. We are not scientists working in Lakshmi Kumar and Sridharan. We are all lawyers. We discuss with the scientists of Indian Institute of Technology, Indian Institute of Science, and we make drafts. No, you should have a different type of spectacle for understanding the technology. Say for example, everyone is sitting on the chair. Your chairs are fixed to land by a rod. 60-70 kgs of weight with a 2 square feet base is fixed. Start our discussion with regard to intellectual property rights. Now, what is the necessity of protecting intellectual property rights? We all work hard in good faith, believing together, believing all. Most scientific developments are building on the past. As I explained, this laparoscopic tool, somebody invented it and we are making a improvised version of that. IPR protection enhanced progress. We know. No patents means no incentives. Mr. Hegde was quoting that some instrument which can be produced by $5 and they price it for some $2,000 or something like that. Do you know which is the company having highest number of patents in the world? Toyota. Have you heard of that? Toyota Jidosha Kabushiki Kaisha. That is the original name. Kabushiki Kaisha means it is a public limited in Japanese language. And next comes your Mitsubishi. Now 99,999 patents are there, and next patent is filed from ours, Indian patent. They are very keen as to each and every single nut and bolt of their production. They are very particular as to that. Some patents they got for 3 years, 5 years protection. Some are utility models. Some are hardcore engines and carburetors, fuel injection technologies, pistons or transmissions. What is the use of having patent or protecting your intellectual property right, or you may call it as invention through patent? See, no patents mean no incentives. There are institutions registering their patent just to prevent others from invention or just to prevent others from entering the market. Do you know this? If I get a patent, there is one company called Warner Lambert, Pfizer International. Anybody heard of it? Pharmaceutical, largest giant pharmaceutical company of US. They got a patent over, in 2003, they got a patent over gabapentin tablet. Gabapentin is a tablet used for reducing your nervous aggressions. It's a mental treatment tablet. It's a process patent, obviously. What is the background of patent is a gabapentin tablet with less than 20% of mineral ion. Now, anybody on this earth produces a gabapentin tablet less than 20% of mineral ion will be infringing their patent right. Now tell me how to produce gabapentin. Anybody, see, 20% and above is prohibited by WHO standards. Nobody should use a tablet more than 20% of anion. And less than 20% these fellows got, and from last 2 years they stopped production of gabapentin. Why? They want to increase the price of the product. How it is possible? Create an artificial void. always patents or protecting the technology or invention through patent will not lead to hike in the price of the product. We call it as non-infringing alternatives available in the market. Say for example, I got a patent over a tablet, and in the market you get a non-infringing alternative or same tablet with different manufacturers having different patent rights, then you cannot make your own prices. That's what happened to the Viagra tablets. Once again, a product of Pfizer. All other alternatives produced by other manufacturers reduced the Viagra tablet rate. Once upon a time, Viagra produced crores of dollars within 3-4 months. Now Viagra is a common tablet. Anybody can produce it. So patents give a financial strength and incentive to the companies. Everybody must know how to play the intellectual property right game. A single intellectual property right or a protection will not help you or may not help you. One trademark or one patent. But like Toyota, when you have a series of patents for starting from a nut to an engine, then you can find that how they start fetching the return to you. Next. What are protected through intellectual property rights? Patents, novel inventions. Now we got different theories of novelty. What is novelty is different. American novelty is relative novelty theory. EU sees it as compulsory novelty. India, it is absolute novelty. We call it as state of art. What is state of art? If an invention, you want to call it as a novel invention, a person who is expert in that should not understand the invention. Then it is novel. Are you able to catch? If I say this mic is novel invention, a person who is expert in mic system should not understand how I produce this mic. If I produce an engine, you go with a mechanic, अरे ये क्या साहब ये तो सब हम करते हैं. Then there is no novelty. Novelty, you can claim that it is a new invention. An expert should not understand what is this. I had not come across any type of machine working like this, even though I am an expert in mics. Then you can claim novelty. No, as we know, laparoscopic tool, as I said, there are scissors which got patents. Katri roll. There are more than 500-600 patents on scissors. I will show you one picture. How you can say that each and every, scissor is a novel invention? Now our section 3 and 5 of Patents Act is very clear. No addition, no deletion for an existing invention can be claimed as novelty. No living organisms, animals, plant varieties can be protected under patent law. But 1 hour earlier we are discussing about Monsanto seeds, organisms, they are not living. You just go through section 3 and 5 of Patents Act. Plants and animals are not patentable, varieties of plants and animals. How you can patent a breed? How you can patent a seed? With a biotechnology, alteration of gene, which is not naturally occurring. That is very important. Which is not naturally occurring. Now, as he rightly quoted, Terminator seeds, they never breed further. You can get patented. You may be heard of this basmati rice issue. How US Texmati they registered, Rice Tech Company. That's how it is. And let us name patent and your turmeric patent. No, in American USPTO, they got a different terms for novelty. Not like India or Japan. Japan is the highest number of filer in patent applications. What is important is, inventor should have a flair to protect his invention. We got a type of Molnard syndrome, particularly in South India. We are very intelligent, but we are lazy. ಏನು ಮಹಾ ಹೋಗಲಿ ಬಿಡು, ದಿಸ್ ಈಸ್ ದ ಟ್ರೆಂಡ್ ವಿ ಗಾಟ್. ನಾನು ಯಾರಿಗೂ ಹೇಳಲ್ಲ, ಏನು ಮಾಡ್ತಾರೆ? ದಿಸ್ ಇಸ್ ನಾಟ್ ಎ ಕ್ವಶನ್. ಇಟ್ ಈಸ್ ಎ ಕ್ವಶನ್ ಆಫ್ exploiting your intelligentsia, or it is a question of commercially utilizing your intelligentsia. You found something, let others use it. Why you are hiding it? After all, you are permitting others to use it. Not giving, you are permitting others with some royalty that you can fix. If you are very good, price lowest royalty. If you are greedy, increase your royalty rate. Then copyrights, as I told, original expressions. And there is a misconception that this cinematograph films, sound recordings, they will get only 25 years of protection only. Only your literary works, they get 60 plus author's life. All others, they vary. Usually, it is a saying that copyright protects a longer duration compared to other this thing. Now, subject matter of copyright differs. What is protected in a novel or literary work? What is protected in a musical work, a dramatical work, an artistic work? Say for example, a film. A story is there written by somebody, actors are there, performers, right? Music is there, music composer, musicians, or a person who is writing lyrics, and producer is there who is combining all sort of nonsensical things and putting in front of you a nonsensical film. Who gets the right over this cinematograph film? Any idea? He put only money, man. Director, he put nothing, even not his brain. You should see MGM versus International Motion Pictures, a case decided by USPTO. Who gets copyright in a cinematograph film? It was decided that only producer should get the copyright, not actors, not director, not musician. Musical tracks per se, they can be released as CD, which carry a different copyright for performance of that. But in total, it's the producer who gets. Computer software is another difficult area, which is termed as literary work. ISRO is our client. We file a series of softwares produced by ISRO. That's why I tell you, all the lawyers should have a little bit of technical bent of mind. When a software is handed over to you, they give you a CD and author's name, author's father's name, and ask you to file the copyright application. You should give a description of copyright. You should give a description of the work. What is this software? How this software is different from earlier softwares? You claiming that it is an original expression, and what are the claims? No, software, whether it is a literary work, I don't know. I will leave the bug in your head, you think it. Then trademarks. Rather than it is protecting the interest of owner, it is protecting the consumers, trademarks. And initially it was registered for 10 years and it can be renewed to any number of years. For each and every 10 years you should renew it. 5,000 is the fees, fixed latest amendments, and you can renew till your business runs. And within 5 years of registration, if you are not using the trademark, then that will be treated as a trademark in public domain. Anybody can use that. If you register a trademark, proposed user, you are not using it, got registered, and you have not started using after 5 years of registration. Once you should go through that TM1, Form TM1 and Form TM51, how trademark is filed. I request all the law students to go through acts and the forms. They will only protect you when you go for interviews to law firms. You should give a proof of use of trademarks to the register of trademarks after 5 years, or he will remove, remove the name from registry. Then designs. What is a design? And beauty part of this Designs Act is, Designs Act protects copyrighting designs. This mic, here a controlling system, a stand, makes noise. This got a peculiar design. Now I want to register this design under Designs Act. What is protected is not the technology, not the process how it works. It is the shape and the copywriting shape. No other person producing the similar mics can copy this design. This is how designs are protected. It is usually the packages, outer looks of the goods,